All right. Well, hello there, AP Government. This is going to be some civil rights notes for those of you who weren't able to take them in class for whatever reason. I know first block on A Day got interrupted in right at the beginning of our civil rights notes. We didn't get a chance to come back to them. So this is mostly for that class, but if you need a little refresher, or maybe you weren't here or for whatever reason, this should help you out with some of the civil rights notes. So, like I said, in class, we aren't going to have enough time to cover this topic in the detail that it deserves, like with everything that we do in this class. So, this is just a quick overview. But as a definition, to return to this, because we talked about a definition at the beginning of this chapter, civil rights is really about making sure that the law applies equally to everyone. So when we think about civil rights, we should think about the Equal Protection Clause of the 14th Amendment. Specifically, this is the federal government's role in guaranteeing protection, typically to groups that have faced discrimination or some kind of historic disadvantage. So again, we're looking at the Equal Protection Clause of the 14th Amendment. That's really where that provides the foundation, the basis for every civil rights movement. The Equal Protection Clause in the 14th Amendment, making sure that the law applies the same to everyone. These are protections guaranteed by the government. So we've talked about these two Supreme Court cases before. These are generally top two of the list of worst Supreme Court cases in U.S. history: Dred Scott versus Sanford and Plessy versus Ferguson. Dred Scott was the case where the Supreme Court said that African Americans, even if free, could not be considered citizens of the United States. That case is overturned directly by the Citizenship Clause of the 14th Amendment. So Dred Scott comes before the Civil War. After the Civil War, the 14th Amendment gets ratified, and that directly overturns Dred Scott. But even after the Civil War, after you get the 13th, 14th, and 15th Amendments, you still get Plessy versus Ferguson. And Plessy versus Ferguson upheld the doctrine of separate but equal. Basically, Plessy versus Ferguson said, hey, segregation is perfectly constitutional. And that Supreme Court case wouldn't be overturned until you get to Brown versus Board of Education in 1954, which says that separate but equal has no place in public schools. And you really start to see the dominoes fall in a big way after Brown versus Board of Education. And we'll talk about some other amendments and laws that helped put an end to the separate but equal doctrine. So Plessy versus Ferguson upheld segregation, said that separate but equal is constitutional. And like I said, these two Supreme Court cases, civil rights is really about undoing the legacy of these two cases and the Jim Crow era that came afterwards. After the Civil War, you get 3 amendments to the Constitution that had to be ratified before the former Confederate states were allowed to rejoin the Union. So after the Civil War, you get the 13th, 14th, and 15th Amendments. The 13th Amendment ended slavery except as a punishment for crime. So no one can be forced to labor without pay except as punishment for crime. If we get a chance after the AP exam to have some more talk about criminal justice reform, we may return to that very important exception. But in a broad sense, the 13th Amendment is responsible for ending the institution of slavery. The 14th Amendment we talked about in detail last time. 3 significant clauses in the 14th Amendment: Citizenship Clause, the Due Process Clause, which is tied closely to civil liberties and your individual freedoms in the Bill of Rights, and the Equal Protection Clause, which is the foundation for civil rights. And then you get the 15th Amendment, which said that no government, federal or state, can prevent someone from voting on the basis of race. So the 15th Amendment says no government can prevent someone from voting on the basis of race. We will explore some rules that had to come after the 15th Amendment to make sure that the spirit of the 15th Amendment truly gets enforced. The 15th Amendment comes right after the Civil War, but it isn't fully enforced for several decades as you get voter suppression tactics, especially things like literacy tests or poll taxes, that even though they were race neutral in their language, were designed to prevent African Americans from being able to vote. So, three amendments after the Civil War, 13, 14, and 15, ending slavery, the 14th Amendment, citizenship, due process, equal protection, and the 15th Amendment, making sure that no one could be prevented from voting on the basis of race. After the Reconstruction era is ended, you get what's called the Jim Crow era, especially in the South, but segregation and racial oppression and racial violence weren't limited only to the South. We tend to highlight the South, but that wasn't the only part of the country where racial oppression was taking place. When we talk about segregation, we can talk about it in two ways. The first and most obvious is this Latin phrase, and I will mispronounce it. Apologies to the Latin speakers, but de jure segregation means by law. You can see the word kind of looks like a jury. That's segregation by law. It's explicitly written into the language of the law. So the kinds of segregation laws that were passed after Plessy versus Ferguson that made explicit these racial divisions would be examples of de jure segregation. De facto segregation means that there is no longer segregation by law, but there might be segregation by circumstance, by tradition, or we might still be dealing with the legacy of de jure segregation. Basically, segregation existed in law for so long that it locked in these patterns of a segregated society, and we're still kind of dealing with that legacy. So that's de facto. It's not segregation by law, but it is. There are still patterns of segregation in the country. During the Jim Crow era, we see African American citizens specifically singled out and excluded from the kinds of things that were used to build wealth, especially for white Americans. So it was much more difficult for Black Americans to get loans to start businesses. Unions were heavily segregated, and so that made it difficult for African Americans to join unions. And it made it difficult for unions to bargain collectively on behalf of everyone. Black Americans were excluded from Social Security because Social Security programs originally did not include workers who worked in agriculture or workers who worked as domestic workers, like cleaning homes or businesses. And a large number of workers in those industries were Black. And so, because those industries were not included in Social Security, many African Americans were excluded from being able to take advantage of Social Security. Housing policy was specifically written and designed in a way to exclude Black Americans from being able to build wealth by securing a mortgage. There were programs created after World War II that were designed to help many white Americans own homes, but those programs specifically excluded Black Americans. And that was by design, and by design at the federal level, not just states. Again, a lot of times when we talk about the civil rights era, we focus on individual states, but many of these programs were designed by the Federal Housing Authority and contributed to segregated neighborhoods. And even Black veterans returning from World War II were excluded from many of the programs in the GI Bill and weren't able to take advantage of some of those educational programs that would allow them to advance and build wealth. So we are still dealing with the fallout from these decisions from only a few decades ago that excluded Black Americans from opportunities to build wealth during the 20th century. A couple of court cases to be aware of. Of course, Brown versus Board of Education is a very significant one to know. This is the Supreme Court overturning Plessy versus Ferguson and saying that separate but equal is unconstitutional. The court ruled that separate accommodations, even if they were exactly the same, which they never were, separate accommodations were inherently unequal. So Brown versus Board explicitly overturns Plessy versus Ferguson and says that segregation in public schools is unconstitutional. And that really starts the domino falling, so that it's not just in public schools, but soon it's elsewhere in the country as well. And then you get Loving versus Virginia, which is the Supreme Court case from the, I believe, early 1970s, where the court ruled that state laws preventing interracial marriage were unconstitutional. So again, Virginia, along with a number of other states, had state laws that prevented interracial marriage. The Supreme Court said that those laws were unconstitutional. And both those cases draw heavily on the Equal Protection Clause of the 14th Amendment. Of course, during the civil rights era, you should have learned this from your U.S. history class. You get Martin Luther King Jr. and his push for nonviolent civil disobedience. During class, we will take a closer look at this specific document, his letter from a Birmingham jail. He wrote it after being arrested in an act of nonviolent civil disobedience. And he was writing to some critics of his tactics who considered themselves allies. They were also working to end segregation and ensure civil rights, but they were critical of Martin Luther King Jr. because they said, hey, you're being too confrontational and you're being too impatient. You need to wait, and you need to wait for us to be able to catch up, basically. And in Letter from a Birmingham Jail, King addressed these critics from people who kind of claimed to be his allies. And he's very critical, where he basically says, hey, we've been waiting long enough, and the only way that we're going to secure civil rights is if we, number one, are nonviolent, but number two, if we directly confront these unjust laws. Basically, King argues that an unjust law is no law at all, that it should have no real power. You do see a divide in the movement. King's popularity sort of crests, especially with the March on Washington, but there are folks in the movement who are impatient with King, and they kind of get a little disillusioned with him. So you see Malcolm X come along. He's much more confrontational. You see the Black Panthers, who are more willing, again, to be confrontational. It is worth noting that in addition to encouraging gun ownership, the Black Panthers also started some of the nation's first free school breakfast programs, where they would provide breakfast for students before school, because they noticed that many students in their neighborhoods were not getting proper nutrition and therefore having a hard time concentrating. And so they started these free breakfast programs, expanded into multiple cities, and the director of the FBI at the time, J. Edgar Hoover, who hated the Black Panthers, said that the most dangerous thing that the Black Panthers ever did was start a school breakfast program and feed children. He said that that was how they were going to indoctrinate students into communism, by giving them breakfast. So the scariest thing that the Black Panthers did, according to the FBI, was feed children. And that program, actually that free breakfast program, basically shamed federal and state authorities into starting free and reduced lunch and breakfast programs throughout the country. So that idea basically came from the Black Panthers. A couple of laws to be aware of here. The Civil Rights Act you absolutely should know that the Civil Rights Act basically took some of the ideas of Brown versus Board of Education and applied them broadly. So this law leads to desegregation of public accommodations. Basically, public spaces are no longer allowed to be segregated. It also leads to an end in discriminatory hiring practices, that you can't avoid hiring someone based on race, ethnicity, or national origin. So the Civil Rights Act of 1964 desegregates public accommodations, leads to an end in discriminatory hiring practices. Just a year later, the Voting Rights Act of 1965 puts an end to literacy tests. So previously, there had been several states had these programs in place where before you could register to vote, you would have to pass a literacy test. And the literacy tests were designed to be unpassable. Basically, they were impossible. This was a way for these state and local governments to prevent Black voters from being able to participate. They would create what were called grandfather clauses, which were exceptions. If your grandfather was eligible to vote, you didn't have to take the test. Of course, no Black American's grandfather at that time was ever eligible to vote. So the grandfather clause only applied to white voters. The Voting Rights Act of 1965, one of the most important things it does is say, hey, you can't have these literacy tests. The Voting Rights Act also required states with a history of discriminatory voting laws to get permission. It was called pre-clearance. They would have to get permission from the federal government before they could change their voting laws. So the Voting Rights Act of 1965 required especially Southern states to get permission from the Department of Justice before they changed their voting laws. And DOJ would look at those changes, determine whether or not they were going to be discriminatory, and then either give or reject permission. That part, only that part of the Voting Rights Act, that pre-clearance part, was ruled unconstitutional just a few years ago. The Supreme Court said, hey, there's a Black president now, so that means there's no such thing as racism in voting anymore. There can't be any racial oppression in voting laws because, look, we've elected an African-American president. So they ruled that part of the Voting Rights Act got struck down as unconstitutional. Within hours, several states had passed new voting laws that included restrictions that made it more challenging and more difficult to vote. Affirmative action programs, we've talked about this before. Basically, these are programs that take race or gender or other factors into consideration when it comes to hiring and college admissions. And those programs have been upheld as constitutional. So this Supreme Court case, Grutter versus Bollinger, said, hey, these affirmative action programs, they are constitutional. All right, we'll spend a little bit of time on civil rights for women, just to kind of show you how far things have come. If you're looking in the 19th century, you might see this phrase, the cult of true womanhood, basically the argument that the best thing that women can do is support their husbands and rear children at home while their husbands go off to work. That is really a product of the Industrial Revolution, the idea of gender roles where women stay home while their husbands go to work. That's a product of the Industrial Revolution and the age of factories. This whole idea of going to work. Remember, for most of U.S. history before that, a lot of people lived on small independent farms, and they, worked in agriculture. And the idea of going to work when you have a farm doesn't really exist. So But nevertheless, this sort of became the predominant philosophy for a while. This Supreme Court case, which won't show up on a test, again, I'm just trying to illustrate kind of how much things have changed over time. There was a Supreme Court case towards the end of the 1800s in which a woman applied to law school in Illinois. She was rejected because of her sex, and she appealed all the way up to the Supreme Court, who told her that law really was a man's realm, and that it was no place for a fragile woman. So fast forward to today, where now there are more women in law school than men, more women graduating college than men. Certainly, things have changed since Bradwell versus Illinois. The 19th Amendment is the one that said, much like the 15th Amendment, you can't stop anyone from voting on the basis of sex. So the 15th Amendment said you can't stop people from voting on the basis of race. The 19th Amendment said you can't stop people from voting on the basis of sex. An interest group to know as far as women's rights goes is the National Organization of Women. And then a few laws to be aware of. The Civil Rights Act of 1964, there was an additional section, Title VII, just like we talked about before, where the Civil Rights Act said you can't discriminate in hiring on the basis of race. Title VII says you also can't discriminate in hiring on the basis of sex. So Title VII of the Civil Rights Act includes not discriminating in hiring on the basis of sex. This part of the Educational Act, Title IX, which you generally just hear referred to as Title IX, is designed to promote equality in education and educational opportunities between men and women. So Title IX is designed to promote equality in educational opportunities between men and women. Frequently, you'll hear Title IX be talked about in terms of extracurricular activities, that there needs to be some equality, some parity between extracurriculars offered for men and offered for women. The Equal Pay Act of 1963 was designed to make sure that there is not a disparity in pay between men and women who are doing the same job. Certainly, your mileage may vary on how successful that has been. There's certainly evidence that suggests that even within the same field, even within the same qualifications and the same education, that women are still paid less than men. And there was a proposed constitutional amendment called the Equal Rights Amendment that made it through Congress, was on its way to being ratified by the states, came very, very close to ratification. The Equal Rights Amendment basically would have said that men and women were to be considered equal under the law. And so that amendment, like I said, got passed through Congress, got ratified by a bunch of states, and then suddenly there was a dramatic opposition led by a woman named Phyllis Schlafly, who basically said that the Equal Rights Amendment would mean that women would have to be drafted. It would mean that there would no longer be separate bathrooms for men and women. She led opposition to stop the Equal Rights Amendment. She got the women in her organization to bake their senators and members of Congress cookies, their state legislators baked them cookies, then sent them to them saying, preserve the separation between the sexes and don't pass the Equal Rights Amendment. So the Equal Rights Amendment languished and has not yet been ratified. So it is not part of the Constitution, hence the question mark here. And then to close us out, I'll cover a few other groups here. So when it comes to civil rights for based on sexual orientation. The main Supreme Court case to know here is this last one, Obergefell versus Hodges. I just want to show you kind of how things have changed over time. So there was a Supreme Court case several decades ago, Lawrence versus Texas, which basically said state laws against same-sex relationships or same-sex sexual activity were unconstitutional. Then in the 1990s, you got the Defense of Marriage Act, which was a U.S. law, federal law, saying that marriage was between one man and one woman. So for the whole country, national law, that was considered the definition of marriage. That law got struck down, in this case, in the early 2000s, US v. Windsor, but it wasn't replaced with anything. So for a while, individual states were making their own laws regarding marriage. And you had some states that allowed same-sex marriage. You had other states that didn't. You had other states that had what were called civil unions, which were kind of somewhere in between, until I believe 2015, Obergefell versus Hodges, the Supreme Court said any state law preventing same-sex marriage was unconstitutional. So this is the one to know, Obergefell versus Hodges. As far as Americans with Disabilities, we've got two laws here to know. The Americans with Disabilities Act requires public accommodations to be accessible. So public accommodations need to be accessible. And just like the Civil Rights Act, you can't discriminate in hiring on the basis of disability. So the ADA, the Americans with Disabilities Act, said public accommodations need to be accessible and there can't be discrimination in hiring on the basis of disability. Individuals with Disabilities Educational Act, or IDEA, said that public school curriculum needs to be as accessible as possible to students with disabilities. Basically, schools need to provide accommodations for students who have disabilities. A disability is not an excuse to not include a student in the general education classroom. So IDEA requires public schools to, as much as possible, include students in the general education classroom and make the curriculum accessible to them instead of excluding students on the basis of disability. And ADAPT is just an interest group to be aware of. They work to change policy and provide lobbying for Americans with disabilities. And the last group, Latino Americans, a Supreme Court case here, Plyler versus Doe, said that public schools must provide education even to students without documentation. So schools cannot prevent students who don't have documentation from accessing public schools. A part of the Voting Rights Act was updated to say, hey, if you've got lots of languages in this particular precinct or district, you have to provide voting materials in that language. So you have to provide voting materials in languages other than English if necessary. Another interest group to know, the Mexican American Legal Defense and Educational Fund works for Latino civil rights. And we've talked before about DACA. The DREAM Act itself never actually became law, but much of what the DREAM Act sought to accomplish was accomplished in DACA. This is undocumented students, or undocumented children, being provided protection from deportation. That was by executive order in the Obama administration. So individuals who didn't have documentation, who were brought to the United States as children, identified themselves to the government. And as long as they finished their education, stayed out of legal trouble, and followed all the proper procedure, they were able to get protection from deportation. So I know that was a lot of different subjects, a lot of Supreme Court cases, a lot of laws. So make sure that you're taking a look at the study guide when it comes to the test. Send me questions on Schoology. Come prepared to class with questions that I can answer before the test, because I know that was a lot in a relatively short period of time. If you've got questions, definitely let me know. But otherwise, I will plan to see you next time for our test on civil liberties and civil rights.